Hello? Hello? Good morning. Hello?
Good morning, sir.
Good morning. Now, are you able to see the screen?
Yes, sir.
Okay. Today, we will discuss privacy violations. As part of our syllabus, we have IT Act. Privacy violation is important in the point of view of cyber security. There will be a question with respect to the privacy violations also. Privacy violation is a major issue. Therefore, even the government has taken certain measures in the with respect to the privacy issues. There's a lot of information that we have to understand today with the privacy. What is a privacy violation? What is a privacy policy? All these things we have to understand. Very first, we have to understand the what is a privacy. I think we have discussed the privacy to some extent, right? Privacy of a person is important. Privacy enables us to create boundaries and protect ourselves from unwarranted interference in our lives, allowing us to negotiate who we are and how we want to interact with the world around us. Privacy protects us from arbitrary and unjustified use of power by states, companies, and other actors. This is some information with respect to the privacy. The data which are private or belonging to a person may be divided into data that can be easily without the access, without the permission of a person, we can access. For example, name. If I call Sahadev Kumar, I need not take his permission to call his name, and some other informations, his address, which are need to be known universally by the government, by the state, by the companies, or other actors, or other persons belonging to him should know the information. In such cases, we do not call it as a privacy violation. Whereas his private information, such as his credit card information, for example, religion information, for example, are totally private to a person. Before sharing such informations, before accessing to such information of a particular person, one has to take his consent. Therefore, it is required either for a person or a company or for any organization also to have their own private information and to fix some boundaries and to restrict accessing the private data to the outside world. That's very, very important. That's why privacy needs some kind of protection. From the perspective of law, it has to be protected. From the perspective of the solution, from the solution out, also we have to implement certain security measurements in order to protect private information of a person, of an employee, of an organization, etc. For any business organization, privacy policy is important. How I will protect the data, personal information of an employee, or how I will collect the personal information of the visitor, how I will transmit that information, how I will provide the security is important. For a social website or social network, many people will be interacting over the social network. The people who are interacting will be sharing their personal information. Then social websites are also having the legal obligation of securing, protecting the people who are interacting with that. Therefore, any business organization, it may be a college, it may be an university, it may be a company, they need to have a policy which explains how they collect the data, how they secure the data, what data they are collecting, all this information. Friends, you might have seen while you are signing for a Google account, there will be privacy informations. Most of the time, we may not read what are the terms and conditions of the privacy information. Simply, we will say, click the yes, 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 we'll go next, 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 and sign a contract, or we sign different agreement. In that agreement, there may be some of the informations, terms and conditions which may say about how they actually share your personal data. Therefore, it is a best practice to read the privacy policy of an organization before signing to it. A privacy policy can be viewed as a legal document of the website or of a business which explains company's details, establishment procedures, and views about the data they get from visitors. Even though it is the integral part of the website, the companies should check if the report is accurate and easily understandable to the common man. The main sections of the document are introduction, information regarding the data, collection and storage of the data, and contact details. It is highly important to prepare a policy which is not having the jargons, so that layman, common man should be able to understand what policy is, what type of data they collect, whether they misuse it or not, what type of security a particular organization adopts should be explained to the persons from whom we are collecting the data. Intrusion of solitude means what? Intrusion, we will encroach the privacy. Solitude, we can say it is a privacy. We encroach the privacy sometimes, and such examples of privacy violations may be intercepting phone calls, peeping, taking photographs without the victim's knowledge or consent, video recording the victim in his or her home without consent or knowledge is another important or unknown, or we may tend to do the this type of violation without our knowledge, but law does not gives an exception for the ignorance. Data Protection Act, countries like India, while they are still thinking to take the step towards privacy or data protection, the countries like UK, they had taken Data Protection Act very seriously a long back. As a result of that, they have implemented Data Protection Act already. The Data Protection Act 2018 controls how your personal information is used by organizations, business, or the government. The Data Protection Act 2018 is the United Kingdom's UK's implementation of the General Data Protection Regulation. In short, it is called GDPR. Everyone is responsible for personal data protection. He has to follow certain strict rules, and these rules are called as data protection principle, and they must make sure the information collected by some visitor or employee or of a particular person is used fairly, lawfully and transparently, and they should ensure that it is used for specific purpose, used for specified and explicit purposes. It should be used in a way that is adequate, relevant, and limited to only what is necessary, accurate, and wherever necessary, and to be kept up to date. It should not be kept for no longer than is necessary. It should be handled in a way that ensures appropriate security, including protection against unlawful or unauthorized processing, access, loss, or destruction or damage. This is the Data Protection Act of UK. India also has thought something with respect to the data protection, but there is a legislation still has to approve, and that act is still in pending. As of now, on December 11th, 2019, Data Protection Act was introduced by Ravi Shankar Prasad, law minister of the central government, but still the approval is pending, not turned into a gazetted notification. As I have explained you in some of the classes, after the gazetted notification, that becomes an law act, and then rules comes as for part of the enforcement of the law or act. India has to still think on enact specific legislation on data protection. However, the Indian legislature did amend the Information Technology Act 2000, IT Act, what we call it as a, in a simple terms, in a short term, or cyber law, wherein the section 43A and section 72A, which gives a right to compensation for improper disclosure of the personal information. So there will be compensation given. Before going to understand what the IT Act has done, what are the different punishments if you violate the privacy, violate private data. Before that, we have to understand personal data. What is a personal data? What are the personal data that we can share without the permission? If you take, for example, personal data of an employer can keep about an employee. Employers must keep their employees' personal data. They need to keep it, but they have to keep it safely, securely, and up to date. Employers can keep the certain data without the employee's permission. Such data fields are name of an employee, address of an employee, date of birth of an employee, sex of an employee, educational qualifications of an employee, work experience of an employee, national insurance number of an employee, Aadhaar number, for example, of an employee, tax code, for example, PAN number, for example, emergency phone number, for example, employment history with the organization, for example, employment terms and conditions, that is, how many hours he has to work, what is his designation, what are his responsibilities, what are the benefits he is having, what are the holidays he is having, what are the absence uh, of the employee for the duty, any accidents connected with the work, any training taken, any disciplinary action taken on an employee. These are the informations an employee can uh, give the information to the employer, and in fact employer need not take the permission of the employee to keep such information. However, there are certain employees information for which he has to take the permission, and such data we call them as sensitive data. Sensitive data, race and ethnicity, religion, political membership or opinions, trade union membership, genetics, biometrics, for example, if your fingerprints are used for identification, health and medical conditions, sexual history or orientation. Employers must keep sensitive data more securely than other types of data. Friends, I had given an example. I had also asked you to do an assignment. An employee of a XYZ company transfers the data of an UK employee, but the friend of an employee who is working in UK stays in Bangalore. In such cases, if the friend of an employee working in UK transfers the information from Bangalore to UK, what are the privacy violations? Please do that assignment. That may appear in your test also. Such several questions you have to explore and be prepared. So such questions based on these act, for example, Data Protection Act 2018 of the UK explains you what are the different sensitive information. Suppose a person passes on the biometric information of an employee, then it is a violation, right? So you explore the remaining part of it. Now let us come back to the privacy policy of a particular business. As you know, privacy policy is nothing but a website's legal document. Suppose if he is having a website or if he is having a business, it is a business document. It explains the details about the company, views about the data obtained from visitors and establishment procedures. Privacy policy is an integral part of any website or business. Should check if it is accurate, comprehensible, even to layman. Here you will understand why privacy policy is important. A privacy policy, as we have said already, it is an integral part of a website or a business, which is a legal document. Company should ensure its accuracy. Company should ensure that there should not be any jargon words involved in it. Therefore, in that way, a company should have a policy. Such policies are very, very important, especially if in the healthcare sector, for example, hospital is maintaining the medical records of the patients, then it should have a privacy policy wherein it has to educate its persons, employees working for the organization. For example, a insurance company person may be working with the hospital. A nurse may be working. A data entry operator may be working on the medical software, right? In such a case, he or she should know what data are private, what data can be transferred or given to somebody, what data can be shared to the outside world without the consent of the person, what data are very sensitive, what data have to be in requirement of taking the permission of the patient before sharing the data. That important information he or she should know. That's why the privacy policy should have a point for educating the employees of the organization in such cases. What is a Right to Privacy Act in India? As per the Constitution of India, we have to speak with respect to the right to privacy because there is no Data Protection Act. Data Protection Act in India has been completely written, ready for approval, but still it has not completely passed and has not received the assent of the President of India. Therefore, we go and refer to the Constitution of India. The Constitution of India encompasses a right to privacy under Article 21, which is a requisite of right to life and personal liberty. Stressing on the term privacy, it is a dynamic concept which was needed to be elucidated. The scope of the Article 21 is multidimensional under the Indian Constitution. Friends, you ought to just understand there is a right to privacy act under Article 21 as per our Constitution of India, which is a requisite of the right to life and personal liberty. What is a privacy? What is privacy? A fundamental right is a question. So Supreme Court already has told in 2017, privacy is a fundamental right for each of its 1.3 billion citizens protected under the country's constitution. Right to enjoy life is in its turn a part of the fundamental right to life of the individual. Under section 72A of the Indian Information Technology Act 2000, privacy violation will be having some punishment. It opposes privacy violation. Disclosure of information knowingly and intentionally without the consent of the person concerned and in breach of the lawful contract has been also made punishable with imprisonment for a term exceeding to 3 years and fine exceeding to rupees 5 lakhs. So this is as per the IT Act 2000 Section 72A. Therefore, you should remember whenever there is a case of privacy violation, you should apply the IT Act 72A and you should say as per the 72A of the Indian Information Technology Act 2000, disclosure of information knowingly and intentionally without the consent of the person is breach of data. It is violation of the privacy of a person, therefore punishable, and it can be both 3 years imprisonment and fine of rupees 5 lakhs up to rupees 5 lakhs. So Privacy and Information Technology Act, do we have the safeguards for electronic privacy? Now, the internal information technology has given a lot of scope for us. A very common man is having a mobile phone today. He can do a lot of things. The cyber crime, a person intended to do some mischievous activity can do easily some infringement, right? Privacy infringement easily happens. Then what our electronic privacy is all about? What is the IT Act? You know, right? IT Act, how does the provisions of the Information Technology Act measures up to the challenges of privacy infringement? Does it provide an adequate and useful safeguards for our electronic privacy? Prashant Iyengar gives a comprehensive analysis on whether and how the Act fulfills the challenges and needs through a series of facts while drawing upon real life example. I am requesting all of you visit the mentioned URL cisindia.org Internet Governance blog Privacy Safeguards for Electronic Privacy and try to understand this. I am leaving this as your assignment. Now I will come to what provisions in the IT Act protect against violations of privacy. This is very, very important. One from the Indian perspective, another from the international perspective. We have taken Data Protection Act of United Kingdom, UK 2018 Data Protection Act. These 2 points you have to remember. At the outset, it would be pertinent to note that IT Act defines a computer resource expansively as including a computer system, computer network, data, computer database or software. That means it is a broad definition. As is evident, this definition is wide enough to cover most intrusions which involve any electronic communication devices or networks, including mobile networks. Briefly then, IT Act provides for both civil liability and criminal penalty for a number of specifically prescribed activities involving use of a computer, many of which impinge on privacy directly or indirectly. This will be examined, okay, in these following sections. So intrusion into computers and mobile devices, accessing them, downloading, copying and extraction of data or extracts any data, introduction of computer containment, introducing a computer virus, causing damage either to the computer resource or data residing on it, disruption, denial of access, facilitating accessing by any unauthorized person, charging the services avoided or by a person to the account of another person, destruction or diminishing of value of information, stealing, concealing, destroying or alerting source code with an intention. All these are listed as a privacy violation when it comes to the electronic data. The Act provides for the civil remedy for damages by the way of compensation, as I have already told you, for damages caused by any of these actions mentioned above. So far we have listed and read out. In addition, any who dishonestly and fraudulently does any of these specified acts is liable to be punished with imprisonment for a term up to 3 years or with a fine which may extend to 5 lakhs rupees or with both. Friends, I request you to explore the following URL and make a preparation for an important question in the perspective of your examination or your internal test. There is a link called naitimes.com. Okay, so let us go to this slide website, and we will try to understand what we have to actually go through it. So I'll come to this. This is the website that friends, are you able to listen this? Able to see the naitimes.com that I have opened just now? Are you able to look at this? Hello?
Yes, sir.
Yes, sir.
So you are there, right? The
Yes, sir.
FTC, so just I am taking to a website where Google has violated the privacy, done the privacy violation and paid a huge amount. Friends, you have seen the YouTube, right? YouTube, have you seen the YouTube? And when you are uploading, we know more than you, because these days we are doing the online courses, and after every online course, a video has been uploaded. In that, they will ask whether this video has been made for the children below 13, right? So generally they will ask that question. That was not there earlier. Even the Google owns the YouTube. So because of some case, because of some punishment made to the Google, then they implemented such privacy policies. I am just interested to explain that. That's why I have taken you for this website. There may be also a question in your test or in the examination. What is a privacy? What is a privacy violation? Name some of the companies which done some privacy violation and taxed with a huge penalty. One such case is Google. So you look at you come to this. Okay, so here children's I am talking about now. The FTC let Google off the hook with a drop in the bucket fine and set a set of new requirements that fall well short of what is needed to turn YouTube into a safe and healthy place for kids, right? Even YouTube was not earlier the safe one. Now it is the safe one to some extent. Children's advocates who lodged their own privacy complaint against YouTube with FTC last year said that Google had simply agreed to abide by a children privacy law it was already obligated to comply with. COPPA prohibits operators of online services from collecting the personal data like home address from children under 13 without parents' verifiable permission. Without the permission of the parents, they have collected the information from the children who are under 13. Merely requiring Google to follow the law, that is a meaningless sanction, said Geoffrey Chester, the executive director of the Center for Digital Democracy, a non-profit group whose efforts in the 1990s helped lead to the passage of the children privacy law. It is right. So you have to read this, and you have to, I'm just browsing and going through this. Please understand. So there was a dispute and there was a complaint lodged against the Google, against the YouTube. Okay, no individual accountability, insufficient remedy to address the company's financial incentives, and a fine that still allows the companies to profit from its law breaking. Mr. Chopra wrote in his dissent, the terms of the right. All these companies are there. Let us see finally what happened. Right, in a blog post on Wednesday about the settlement, YouTube chief executive Susan said that nothing is more important than protecting kids and their privacy. Then they finally agreed, right? and from its she added from its earliest days, YouTube has been a site for people over 13, but with a boom in family content and rise of the shared videos, the likelihood of children watching without supervision has increased. Therefore, YouTube had said that not only had it agreed to stop placing targeted ads on children videos, it would also stop gathering personal data about anyone who watched such videos. Even if the companies believed that the viewer was an adult, company also said it would eliminate features on children videos like comments and notification that involved the use of personal data. So this is one case with respect to the privacy violations. I am requesting you go to this particular website, spend more time, leisurely, give sufficient time and understand what Google has done the mistake, what is the amount of fine it has paid, right? So that you have to clearly remember. See, that's given also here. In 2012, Google agreed to pay $22.5 billion to settle trade commission charges that it had violated the 2011 order by deceiving users Apple Safari browser about data mining practices. This browser was collecting some personal information. See, these are the things that we need to take care of with respect to children, with respect to adults, with respect to company, whether our company browser is collecting some information, something of that kind we have to see. Otherwise, it becomes a serious issue. Just I am motivating you people to look at this website and be prepared for some questions. You have to understand what is privacy, what is privacy violation, what are the examples of privacy, and this case study you have to understand. In the next class, we will look at pornography, child pornography. Already we have discussed what are the different problems of child pornography, write an article on it, and how you can give the IT solution for this. I request all of you to think towards the different solution in examination. You may get such questions also. One important question for today's the first test innovative question is children child pornography and IT solutions for it. I request all of you to think towards that. I know while covering such points where I have to motivate you to look at the different resources and make a comprehensive study and prepare for your innovative questions and case study questions. I have to tell you a lot of things. And since in the class the questions topics are keep repeating, if you constantly continuously attending the classes, or in case of connectivity problem, at least if you are watching all videos in your leisure time, there is nothing difficult for you to write the test, first test, and all the informations I am just passing on to you. Yesterday I had sent a detailed information guidelines for doing the case study preparation. I think all of you have received the email with respect to that. Please go through the yesterday email, and today tomorrow also I'll be sending some more informations with respect to buffer overflow attack, steganography and cryptography. And today's video also I am uploading along with the PPT that I am prepared. I will share with you. Friends, do a constant study and understand the cyber security to a greater extent. Do decision of your project based learning. That's very very important. If you take up some question, and solving try solving it, you will definitely, for example, Divya, she has said his project based learning is online phishing, detection of it, and developing a mechanism of anti phishing. And I, as of now, I have not received any other problems that you have selected. Please do this. This is very very important. After that, we'll not be having much time to do project based learning. With this, I would like to conclude today's session on privacy, and I would like to say privacy is the personal data or personal information of a person without his consent. We cannot share it with the outside world. We cannot capture him. Whereas certain fair use supports the information such as name of a person and the phone number, contact number, address, such information can be shared. But largely, a software electronic privacy is thought to be a very serious offense. Privacy violation is a serious offense. IT Act 2000 has added some acts. It has made amendment, and a particular act like Data Protection Act of UK is not yet enforced, not yet approved, not yet obtained the president consent in India. It has to be obtained. It is on the table to be passed on December 11, 2019. Ravi Shankar Prasad, he has introduced, and it was earlier also. It was prepared in 2018 December. Again in December 2019, it was put forward. I hope at least by December 2020 it will upload. It gives you a lot of weightage, and our data has to be protected. Google, the microphone of a mobile phone may catch our information, and many things, right? So you'll be having our privacy violation easily, so that has to be protected. Otherwise, the especially the common man will be in the problem. And like the coronavirus, will not be knowing what type of virus, what type of strange unknown softwares mechanism will be working to catch our private information and encache. So in that constant context, privacy violation and mechanism development for privacy violation through the software IT solutions is very, very important. I request all of you to once again to focus on this important topic in point of view of your personal understanding, in point of view of your test, main examination, and in your career point of view as well. Thank you for patiently listening. Thank you one and all.